It's something I wanted to do a recap, just do a recap for be able to like again back in covered. So we looked at the contents of articles.
Yeah.
So there was this bit of alteration of articles. Alteration of articles. I think we had just started. We just started where I want us to start. Then I think we can look at. So we already looked at the legal effects.
Yeah.
Legal effects we're going to look at them. But in this case, under restrictions, so it is important to know regarding alteration, what is basically required under alteration of articles, alteration of articles, and also remember the restrictions upon alteration, restrictions upon alteration. The articles, restrictions upon alteration of the articles. So, for example, if you look at the so I think I'm able to do the printouts of the handouts I come with them. But if you can be able to open your notes, you'll be able to see under the restrictions, number one, you are being told the alteration must not be inconsistent with the express provisions of the Act. So that when you're having to alter the articles, when you're altering the articles, the alteration, because now this says the articles are the rules governing the internal affairs of a company. They are rules governing internal affairs of a company. So you can actually end up having to alter them. But now in this case, when you alter the restriction number one, you shouldn't alter them to go against the provisions of the law, which is exactly what the Companies Act. Remember, there's something I told you about the article. But in this case, there are two options. In this case, you have when you're having to form your company, you can either prepare your own articles of association, or alternatively, you can use the model articles under the Companies Act. So in this case, you have to prepare your own articles. Because in this case, maybe later on you're having to alter them. Ensure that in this case, they are consistent with what the law says regarding how you can be able to prepare them. For example, in a situation, I just go to give an example, in a situation whereby you are altering these articles, there could be a provision giving rights to the members of the company, maybe in this case, to be able to petition for the winding up of the company. But when you end up having to alter them, you deny them that right. That right, it is actually already provided for under the Companies Act, under the law. So in this case, you cannot be able to alter the articles. In this case, go against what has been provided for by the Companies Act. Then number two, restriction. The alteration shouldn't produce a conflict between the articles and the memorandum of association. So it shouldn't actually produce a conflict between the memorandum of association and the articles of what association. In any case, this one happens, then what will end up having to prevail is what is actually contained in the memorandum of association. That is restriction number two. In any case, the author ensure that in this case, there shouldn't actually be a conflict of what is actually provided for in the memorandum and what articles. If it happens, the provisions of the memorandum what they actually prevail. Then restriction number three, you shouldn't actually alter to sanction anything that is actually what's illegal. So no alteration should sanction, no alteration should end up having to sanction, should sanction illegal acts, should actually sanction illegal acts. So no alteration should end up having to lead to the company having to be involved in what illegal activities. So that is the case that would be restricted. Then number four, the alteration shouldn't actually be inconsistent with the order of the courts. It should not be inconsistent. It should not be inconsistent with the order of the courts. The order of the courts. The order of the court. It shouldn't actually be inconsistent with the order of the court. For example, if the court gives out an order, in this case, the company should be able to follow a particular or certain guidelines. And of course, they alter the articles. In this case, states inconsistency, what in this case has actually been provided for by the courts, then that kind of an alteration won't be able to prevail. Then number five, the alteration should be made in good faith. The alteration the alteration should be made in good faith, should be made in good faith, made in good faith, and best interest of the company, and the best interest of the company, and the best interest of the company. Doesn't matter if this inflicts hardship on a minority, hardship on a minority, hardship on a minority. Doesn't matter in this case, it is having to inflict hardship on a minority. Doesn't matter in this case, it's having to inflict hardship on a minority. Hardship on a minority. So in your notes, there's a case law known as Side Bottom versus Capital Limited, which you'll be able to see. It says directors of a company held the majority of the shares. The company altered the article so as to give power to the directors to require any shareholder who competed with the company business to transfer his shares to the company. So directors of a company in this case ended up having to alter the articles to call upon that any person who's actually having to carry on a competing business, that person was supposed to transfer his share to a nominee of the directors. It was held in a court of law that the alteration was valid as it was made in the best interest of the company as a whole. So you can be able to see in this case, it was having to inflict a hardship on a minority shareholder. Which kind of hardship? Him having to be evicted from having to be a member of the company. But overall, it was for the best interest of the company because this minority shareholder was carrying on what a competing business. The minority shareholder was carrying on a competing business. He was carrying on a competing business. So in this case, it is made good faith, best interest of the company because this was a person carrying on competition. It doesn't matter. I believe in this case, it inflicts hardship on him by having to be evicted as having to be a member of that company. Then number 6, an alteration to increase the members' liability will only bind those who consent to it. If the alteration is to increase, members' liability, this will apply only to those who consent, to it. So what when you have to buy it, who consent to it. So you might be able to remember what we learned about liability of a member, that you cannot just be able to increase without their consent. So there are only those situations, maybe circumstances under which you could end up having to do what? Maybe increase the liability of a member. For example, in this case, if they consent to it, or maybe in this case, if they buy more shares in the company. So if in this case, you're altering the articles, in this case, for example, increase the liability of a member, then they should be able to accept it or consent to it. Then number 7, alteration must not actually constitute fraud on the minority. So alteration shouldn't constitute a fraud. Alteration should not constitute a fraud on the minority members. A fraud would be, for example, having to be forcefully evicted without any reason. So that's having to do what? Perpetrate a fraud against what? A minority. Well, by the majority, for example, they end up having to gun out. Because they decide they're going to evict one of the minority shareholders from the company. So that simply means that in this case, that minority shareholder might not have actually, for example, consented to it or accepted it. But as the way as far they're having to do it, is that they want to forcefully evict this particular minority shareholder. So if that is the case, that is like having to perpetrate what? A fraud on the minority shareholder. So any alteration with regard to having to call upon a minority shareholder to be unfairly evicted from the company, and that is like having to perpetrate a fraud on the minority shareholder, and therefore that one is actually restricted. So another restriction is where the alteration affects class rights. If the alteration affects class rights, then the variation of class rights rule should be applied. The variation of class rights rule should be applied. If the variation is affecting class rights, if the variation is affecting class rights, then the class rights variation rule should be applied. If the variation affects, class rights, then the class rights rule, then the class rights variation rule, variation rule should be applied. Class rights variation rule should be applied. If the variation affects class rights, then the class rights variation rule should be applied. In this case, we simply mean you can be able to check your notes, but you don't have them. I bring you the handouts. So next time I come with the whole bunch. Then, so in this case, if the variation affects class rights, then the class rights variation rule should be applied, whereby in this case, if the company wants to buy class rights, so when you talk about a class rights, you know, in a company you have classes of shares. Tulikuwa tumesema unaweza kuwa na njibu gani? Ordinary shares. Remind me your name. Don, yes, Don. Different shares, amongst others. And of course, there's something I was able to mention to you that in this case, all these shares, they have what you call rights. For example, for preference shares, for those who hold preference shares, they get preferential treatment in the company, whereby the rights they have, for example, they get dividends before any other class. For example, for holders of ordinary shares, the holders of these shares, they can be able to control the affairs of the company through having to do what you vote at general meetings. They'll be paid as the last person whenever the company is to be liquidated. So they pay all past preference shareholders, then they pay them. What I'm just trying to describe are what rights. So let's say, for example, now in this case, remember, you see, one of the contents of the articles, it is the rights attached to the classes of shares. So let's say, for example, they want to buy them. The company won't just buy them, but of course, they'll have to follow what? The right procedures. For example, if in any case they want to change the rights of the preference shareholders, maybe it could be they want to change the right of dividends because their dividend is normally at what specified rates. What normally happens, a meeting of the members of that class of shares has to be convened. It has to be convened. Then, of course, now in this case, they'll be able to vote and decide whether in this case the variation can happen. So through a special resolution by members of that class of shares, then they can be able to approve what? The variation of what? Class rights. So of course the company proposes, but until in this case, for example, members of that class of shares are met in a meeting and approved of such, is when the rights can be varied. So in that case, they are having to alter the articles to allow for the change of the rights of preference shareholders. They must ensure that procedure has been followed, whereby the meeting of the members of the class of shares has been convened, and a supermajority, that is 75% plus of the voting rights of that class of shares, have approved of it. But now in this case, if you have 75%, which percentage is remaining done? 25%. So already we've been able to say that they should be able to come to a meeting, members of that class of shares approved by a super majority. But now in this case, we could be having minority. Maybe it was 76, so 24% didn't actually, for example, accept to it. This 24%, less than that, so this 24%, amongst them, at least 15% can petition the court to object to the variation. So although majority have already approved, but while a minority for your class of shares, they can run to the court. So they are actually allowed under the law to run to the court and, for example, in this case, object to the variation. Petition for objection of what? Variation of the class rights. So if they object to it, we talk about having to petition, they, for example, present the reasons. That's why they say they don't want what? the rights to be varied. So the court will listen to that kind of answer, and because what will happen if they bring valid reasons, the court can in this case give out an order for the variation not to do what to happen. So if that is the case, then that is the procedure is actually supposed to be followed before they can alter the class rights in the articles of association. So in this case, in simple terms, to summarize the whole story, I've been able to say if variation affects class rights, then the class rights variation rules should be applied. What? Convening of a meeting, supermajority approve, and of course, the minorities can be given a chance to object through a petition in the court. That case, the proper procedure would have been followed. So they would just ban, because in this case, they'll be altering the rights by having to follow what the rights procedure. So another, in this case, restriction. So an alteration may not have what we call what a retrospective or backdating effect. The alteration shouldn't have. The alteration should not have a backdating effect. A retrospective or backdating should not have a backdating effect. Should not have a backdating effect. Should not have a backdating effect. And you find backdates. So we may change Leo articles up on a similar like from 1st of May. So it is basically for today moving forward. It is for today moving forward. It is for today moving forward. It is for today moving forward. Then the last one, in any case, for example, there's actually an alteration to change the privileges of a private company. So such kind of provisions, such kind of alteration shouldn't, for example, in this case, lead to a conflict of the articles, or maybe the Companies Act with regard to definition of what exactly what a private company. For example, a private company is described under what the Companies Act in terms of membership, in terms of restriction, in terms of transfer of shares. So when you're having to alter the articles, it shouldn't actually basically conflict what is actually provided for, in this case, as what is actually a private company under the Companies Act. So if you're having to alter the articles, don't actually basically end up having to bring upon provisions that in this case conflicts as what is actually basically having to define what a private company. So I think those are part of the restrictions. So it was actually very important that I actually emphasize on them, because like I said, they can easily test, and of course we'll be able to look at past paper questions regarding these rules or restrictions regarding what? Restrictions on alteration of articles of association. So I think we have already looked at legal effects of the memorandum, whereby we talked about it binds companies to their members, it binds members to the company, it binds members inter se, it binds members via members, members. So I want us now in this case to start. I want us to start on the rule in Royal British Bank versus Taquans, or the doctrine of constructive notice. So the rule in Royal British Bank versus Taquans. So we can start with the first doctrine here, the doctrine of constructive notice. So this doctrine of constructive notice, it states, so the principle of doctrine or principle of constructive notice simply states that once a company is actually formed, once a company is formed, once a company is formed, the articles of association and the memorandum of association become readily available documents. Documents at the register of companies, and can be inspected upon payment of a fee, can be inspected upon payment of a fee, can be inspected upon payment of they can be inspected by any third party. So maybe you want to know more about what the company, what you simply need to do and able to pay up here, the registrar's office, the registrar of company's office, and of course they give you access. Remember, we are saying when you register the company, do what? Deposit the documents as part of the requirements to do what? Form a company. So the doctrine of constructive notice, it clearly indicates you have a notice. You have a notice of these documents because they are deposited there. So you can, for example, in this case, pay a fee, and you can be given access, for example, to be able to access this particular documents. And of course, you'll be able to know more about the company. You, for example, in this case, try to understand what are some of the rules or provisions regarding maybe what are the objectives of the company, rules regarding, for example, in this case, the members of the company, rules regarding, for example, in this case, the borrowing powers of the company, because in the articles, part of the content we say what is normally contained there is the borrowing powers of the company, amongst other contents. So once you get access to that, then you'll be able to have what we call what? A notice about these what documents. But now we have the indoor management rule. The indoor management rule, or sometimes we normally refer to it as the rule under the rule in Royal British Bank, the rule in Royal British Bank, the rule in Royal British Bank versus Taquant. The rule in Royal British Bank versus Taquant. Or sometimes you can just refer to it as the Taquant case. Sometimes the examiner can just call it the Taquant case. So the indoor management rule or the rule in the Royal British Bank versus Taquant. So of course, I've already been able to explain what the constructive notice is. So what happens under the indoor management rule? This indoor management rule or the rule in Royal British Bank versus Taquant it actually opposes this doctrine. It opposes this doctrine. It actually opposes this doctrine. So even though we are going to say that you have a notice of these documents, that because they are deposited there, they are registered there, that a third party dealing with the company can be able to access them. This third party is actually limited to some extent. He cannot, for example, go ahead and actually try to find out the minute affairs, how the minute internal affairs of the company are usually governed. So it just only basically restricted to what is actually contained where in the articles and what memorandum. But of course, there could be minute internal procedures that have to be undertaken, for example, to support what is actually contained where in the articles of memorandum. For example, we can go to say we have the Kenyan Constitution, but in this case, they are supporting acts of parliament that in this case can be referred to or maybe be relied upon to support what is actually contained where in the mother law, or law of the land, or the supreme law of the land. It is supported by what? The laws made by members of parliament in parliament. So the same case, the articles is like in this case, just the overall constitution. But in this case, the minute internal details as how things actually happen, you cannot actually be able to have access to it. You cannot actually, for example, be able to have access to it. So in this case, this rule of the indoor management rule simply states that in this case, even though we are having to say that these documents are readily available documents that you can be able to access at the registrar's office, you as an outsider or a third party, you don't have the capacity to go to the extent of trying to find out how the minute internal procedures of the company are normally undertaken. A scenario like this one, for example, you're having to say that in the articles of association, we're able to have what we call what the borrowing powers of the company, borrowing powers of the company. You can be able to say we have what the borrowing powers of what of the company. Maybe that is part of the contents. So in this case, for you to know what extent the company can be able to borrow, you can be able to look at the articles. They'll be able to explain to you. But let's assume you look at these articles, and because they are having to indicate the company can borrow, the company can borrow, the company can borrow. Let's say, for example, 2 million. 2 million. The company can be able to borrow 2 million subjects, which is actually subject to approval, by the company through a board resolution, through a board of directors, board of directors resolution. Maybe it could be through a resolution passed by the members of the company. So when you in this case, of course, you can get the articles, they can go up to 2 million, but we do have that capacity to go and actually ask for this resolution. You would not be able to have the capacity because those are what internal procedures. The internal procedures, you can never go to the company and start asking them, I need to get all the board resolutions. Having to approve the 2 million. So once you read up to this particular extent, and for example, they approach you as a lender, you just lend the money. We just able to lend the money, so long as it's exactly approved under the article. But in this case, authority likely be approved, that is exactly an internal procedure, It is important to lend within the provisions of the article because any lending outside the articles will likely be referred to as having to do ultra buyers. Any act beyond what is actually provided for in these documents, we call it an ultra buyers act. And then in this case, in such kind of scenarios, the company is not normally held liable. Remember, it is a drive company, they need articles na memorandum. It only kifanyika outside the boundaries of these ones. You see shida ya company. The company cannot be responsible. So any act beyond what is actually provided for, either in the articles or the memorandum, kind of an act, we call it ultra bias. If in this case it is within the articles, we call it intra bias. Having to act within what is actually provided for in the articles or a memorandum of association. So therefore, the essence of need, for example, a lender having to be keen by getting these documents and knowing to what extent the company can be able to board to avoid blunder ultra bias. Because company and the local statement, that is not our responsibility. According to our articles, we are not the one who are supposed to service alone beyond 2 million. Therefore, you go to the person who came to you to borrow the loan on behalf of the company. Most obviously, it should be directors. Probably directors of the company or a representative of the company. They will be liable for that loan. But you can't claim it from the company because it was an ultra bias act. Overall, generally, ultra bias acts will end up having to make the company not to be liable or responsible. Liable or not actually responsible. So in this case, if you have borrowing powers and in the articles they have indicated the company can borrow up to 2 million subject to approval by the company to avoid resolution. You will end up having to lend the money up to 2 million. But you can't end up having to find out, for example, if that resolution was passed or not, because it is an internal affair. So if it happens, our petition board resolution, then wakaboro, hawezi ukaanza kusema ni ultra bias. They be responsible. The company will be responsible. Because you as a third party, even though you are having to say under this doctrine, you can access them. You are limited to a certain extent, whereby you cannot go to the extent of trying to find out how the minute internal affairs of the company are usually managed or governed. So to that extent, you are protected as a third party. So if they borrowed 2 million, which was never approved by a board resolution, the company can't claim they won't pay exactly ultra bias. Those who are internal workings, those who are internal problems of the company. So you are safeguarded, you are being protected. From in this case, the doctrine of constructive notice, through the argument, you got access to them. You got access to them, but of course, as far in this case, the approval was supposed to be done, you cannot be able to tell because it was still an internal working. This was a meeting of board of directors and they passed a resolution. So even though say the article,
Hiyo nilitumiwa na Dan, so hata mimi nimeshindwa. Nimeiona, actually nimeiona.
You are limited to certain extent, whereby you cannot
Unasema
go to the
nilitumiwa hiyo soft copy. Hiyo
how the minute
hard copy ni kwa file.
So if any matter arises beyond what is actually provided for, within the company or the internal workings, you are the third party, you should actually be done what you blame. Whenever I leave to your SRO, or salary. So this indoor management rule or the rule in Royal British Bank versus Zambia, it tries to oppose this doctrine of what's constructive notice. It's trying to oppose.
Nimeiona kwa sababu nilikuwa ni print nikajiuliza ni hiyo ama nikaangalia yenye nilitumiwa hiyo nini Excel kuona hivi kwa hivi.
It protects you as a third party. So if you go to the specific case law itself, because it is very important to understand what is happening, the Royal British Bank versus Tarquin case. So you need to be very careful about it to listen very keenly what happened. In this case, the articles empower the directors to borrow money, provided they were authorized by a resolution passed at a general meeting of the company. Just what I'm trying to explain, this scenario I'm having to use. The borrowing powers allowed for the directors to do what? To borrow money. So long as it was approved. Now, in this case, it's not a board resolution, but in this case, it is a members' resolution. Members of the company, what? Members of the company, resolution. So that is what the articles allow. So it gave the company the powers to borrow. And in this case, in fact, they have not put the amount. They are just saying in the articles, kampuni inaweza kopa pesa so long as hiyo pesa imekuwa approved na nani, members of the company through what? A resolution. But just even before we go back, we say you cannot get access to this what resolution. So you are safeguarded or practically protected. So utapeana tu hiyo pesa, you are probably when you approve. So we don't want to know if in this case it is within the articles or not. So we are lend the money. I'm assuming they met, because that is actually what an internal working. So what happened exactly? Mr. Tarquin was the official manager. This guy was actually an affiliate for a company. He was the official manager of the insolvent Cameron's Holbrook, Steam, Coal and Swansea and Longaray Railway Company. It was incorporated under the Joint Stock Companies Act of the year 1844. The company had given a bond of £2,000 to the Royal British Bank. Major bond, according to the company, yes. Government kupea bond inamaanisha kwamba this case umewalend pesa. So what happened? The company where this guy was an liquidator borrowed money from the bank. What? £2,000. What? 2,000 what? Pounds. So they borrowed money. So the company had given a bond of £2,000 to Royal British Bank, which is secured the company's drawings on its current account. The bond was under the company's seal, signed by 2 directors and the secretary. When the company was sued, it alleged that its registered deed of settlement, the articles, they alleged that in this case, the articles they registered with the register of companies, the directors only had power to borrow up to an amount authorized by what? A company resolution. So they argue that in this case, sisi tunaweza kopa pesa, but now in this case, your pesa lazima ikuwa approved na nani? The members of the company. But having been able to check the internal workings, they realized our members are work with it. But still, the bank did what? Lend the money, assuming that they had passed what? Resolution. So this liquidator alikuwa anataka kuruka kulipa hii bank, hakuwa anataka kulipa. Alikuwa anasema the borrowing was actually what? Ultra bias. Simply because he was arguing that in this case, in this company, there was no such kind of resolution to approve that borrowing of what? £2,000. But you were to use you ilikuwa what? Ultra bias. Alikuwa anataka kuruka hiyo story awambie mwende kwa directors ambao walikopa hiyo pesa. Because it was not what within the articles. But what in this case when the bank was lending, they read the articles, and of course they clearly understood the company can borrow, but the borrowing is supposed to be approved by what? The members what? Resolution. But did they have the capacity when the ones to lead the resolution iko wapi before peane pesa? That is not their responsibility. Those are internal workings. Those ones are not provided for where? In the articles. They're not actually provided for where? In the articles. So wakapeana pesa rosa, assuming they actually approved. So the liquidator, sasa wana align creditors during liquidation, they want to pay them. Kampuni sasa imeenda chini, wanataka kwanza kulipa creditors, akapigwa kwa huyu British Bank. Alikuwa anataka kuruka hiyo story kwamba ilikuwa what? Ultra bias. Without him having the knowledge that in this case, this bank is actually protected for under the what? The indoor management rule. That in this case, even though these articles were registered, this bank didn't have the capacity to go to the extent of trying to find out how the minute internal workings of this company are normally undertaken in terms of what's having to borrow money through what? Resolutions. So long as they read the articles and clearly understood, the company had the power to what? To borrow in the articles. You simply lend money. So in this case, this is what actually happened. A resolution had been passed, but not specifying how much the debtors would be able to borrow. The judgment before the court. So the judge, he said the bank was deemed to be aware that the debtors could borrow only up to an amount the resolution did what allowed. The articles were registered with what the company's house. So there was what constructive notice. But there was actually constructive notice because they had done what registered them. But it's now where the point is. But the bank could not be deemed to know which ordinary resolution was passed because these were not what registered. These ones you don't actually register them. The members' resolution to borrow, you don't register them. So you can't in this case blame what? That the bank lent money what? Ultra buyers. You can't blame them. You cannot actually blame them because they don't have that capacity. They've just lent what? The money. They just lent the money. So the bond was valid because there was no requirement to look into the company's internal workings. So your person for valid £2,000 liquidator. Ilikuwa lazima yetu pay the money. There was no option. Simply because the Royal British Bank was acting prosecuted for under what the Indo Management Rule, which said even though these articles are simply registered for documents, and in this case you can go to access. You as a third party like Royal British Bank, you don't have the capacity to go to the extent trying to find out how the minute internal affairs approving resolutions are normally done in the company. Those are internal workings, they are the internal problems of what of the company to deal with. So this is the Indo management rule that the company's Indo affairs are the company's what? Problems. Are the company's problems. So this rule, it has the exceptions. It doesn't actually prevail always for children. Sometimes Royal British Bank can find itself not having to be protected. Therefore, the essence of having to look at the exceptions under the rules. The exceptions under Royal British Bank versus what? Exceptions of the rule in Royal British Bank, exception under in Royal British Bank versus appointments. British Bank versus appointments. What are the exceptions? So we just want to look at situations whereby, for example, now in this case, Royal British Bank couldn't have been protected. So number one exception is, for example, in a situation whereby you had the knowledge of an irregularity. In this case, the third party has knowledge of an irregularity. If the third party has knowledge of an irregularity. If the third party has knowledge of what an irregularity. So a person dealing with the company will not be entitled to protection under the rule if he has noticed that the prescribed procedure as laid down in the articles has not actually been complied with. For example, if you have knowledge, you can be able to have knowledge that in this case, probably there's actually an irregularity in that process that is having to be undertaken by the company. Then you cannot actually be protected under what? The rule in Royal British Bank versus number two exception, whereby you cannot actually be protected. Yes.
How would they know that how would they verify?
It depends upon the circumstances under which, for example, in this case, you're having to deal with what? The company. So maybe in this case, you have privy information that in this case could be able to tell, for example, the procedure undertaken by the company is irregular. Probably news could be out there, for example, having been published. Probably in this case, this is what has been happening in the company. So you have what? The knowledge. You have the information, but you still need what? Still going to directly deal with what? The company. Probably in this case, there could be litigations before the courts. Some of these litigations are basically public information through newscasts. They can be able to talk about that company having been involved in what? A particular procedure. But you still need what? I don't know, you close your eyes and still need what? Ended up having to deal with the company in the same way. You have the knowledge what is having to happen between you and the company is irregular, but still you did what? You went ahead. You went ahead. So in that kind of a scenario, in this case, you cannot actually do what's being protected. There could be a number of what court litigations that are all over news. Different banks had lent money to that company. But later on, they realized that in this case, proper procedure was not actually followed within the company. But now in this case, I don't know what was your accepted that in this case, you still did what went and actually dealt with the company. So in that case, you won't actually be protected. Then number two, forgery, where, for example, this case, forgery is actually involved. So where exactly forgery? If there is a forgery involved. For example, in this case, signatures or maybe directors have been forged on the contract of or agreements of borrowing. So you can say on the contract or the agreements of borrowing. So the signatures had actually been forged. So in this case, you have knowledge. But in this case, there was actually forgery. On the documents involved, for example, in having to deal with you as a third party, then you cannot actually be protected as what? As a third party under the rule. Then number three, negligence on the part of the outsider. Negligence on the part of the outsider. For example, say failure of duty of care. 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 So in this case, for example, you have a duty of care, maybe to go to the extent of trying, for example, find out more about the company, but you fail to undertake that. You, in this case, you fail on what? Your duty of care. You didn't actually take any step, for example, to carry out further investigation. Yet you have the capacity. You had what? The capacity. For example, carry out further investigations about the company before you can be able to do what? Deal with the company. But what you did is says, you just proceeded, you acted negligently. So the elements of negligence, you failed on your duty of care, yet you have what? The capacity. Maybe in this case, you are a financial expert, or you have the knowledge or the know-how. For example, how we can be able to undertake what? Investigations on matters involving what the company before you deal with it. But you never attempted to do it at all. See, that can actually be discovered, then of course, now in this case, you can't actually be protected under the rule in Royal British Bank versus Taquant as a third party. Number four, it could be no knowledge of the articles at all. No knowledge of the articles at all. No knowledge. If it is discovered, you have no knowledge of the articles. No knowledge of the articles of association. So, for example, you did not even make an effort or attempt to pay the fee at the registrar's office to read them. So, no knowledge of what the articles. If they ask you to produce the copy, you don't even have that particular copy. So, if that is the case, then the rule won't actually end up having to protect you. Then the last one, acts ordinarily beyond the apparent authority. The apparent authority under the company's act beyond. Acts ordinarily beyond the powers or authorization, beyond the powers or authorization, under powers or authorization under the articles of association. Under the articles of association. So, for example, in this case, the acts that are going to be undertaken, you can, for example, in this case, discover they are not actually authorized under the act, but you still deal with the company, then the rule doesn't actually protect you. You can only be able to protect you, for example, if you act within what is actually provided for in the articles as powers and actually what's authorization. If directors, you are having to deal with directors, then the act they are going to be involved in have actually been approved under the articles. Because the articles provide for the duties and powers of what directors. So as we deal with them, be able to, for example, this says try to understand the articles exactly. What are they giving as an authorization within the company? what are the kind of powers they are having to give even to what to the directors before you deal them. So in this case, you can be able to know, you can clearly be outlined in the articles, yet you still deal with the company, then the rule cannot actually be able to do what to protect you as what. So those are the exceptions under the rule in Royal British Banks versus Sub-1 versus Sub-1. So the last bit under the top key is actually certificate of incorporation contents. So the contents of a certificate of what? Incorporation. So this is what we already looked at previously, but then this is we can just be able to elaborate on it. The contents of a certificate of incorporation. The contents of a certificate of incorporation. The contents of a certificate of incorporation. So we are looking at the contents, the last bit of the second topic, the contents of a certificate of incorporation. This certificate of incorporation is what you'll be given as a document to authenticate indeed that your company has been formed. And so most obviously what will likely be contained there, it is the name of the company. You have the name of the company, name of the company, name of the company will be there. Number two, date of incorporation will also be there. The dates of the company's incorporation, date of the company's incorporation, dates of the company's incorporation. That's when the company is actually incorporated. The number three, it allows a unique identifying number or unique identity number. So a unique identity. It allows a unique identity number. A unique identity number. It allows a unique identity number. Then number four, what will also be there? It will be able to indicate the type of the company. So it will indicate the type of the company, type of the company. In this case, i.e., whether limited, i.e., whether limited, whether limited, or unlimited, whether limited or unlimited. So you'll be able to indicate the type of the company, whether limited or unlimited. It will indicate the type of the company, whether limited or unlimited. Then of course, as to whether the company is private, whether the company is actually also private, or whether the company, or it can be, whether the company is private, whether the company is private or public. The company is private or public. So some of the types of companies that we have having to be formed, end up having to be formed, end up having to be formed. So that is basically what will likely end up having to happen with that. So the certificate of incorporation and likely what they want to do. Of course, once the company is likely formed, yes. You think?
Yeah, how yeah. Or it's just the physical.
Yes, you must have seen it.
Yeah.
That is, it doesn't have. So regarding shares, it's now on this this document. But I just said this one is just like just the certificates.
Yeah.
So you just have the name. So the few key details about what the company. But now you want to know more about the shareholdings we put into the memorandum. So the memorandum will go to break down all those ones. But that is that basically what you're likely to contain is the certificate of incorporation. So in this case, once you be given, then you can go to commence business as per the dates indicated on the certificate of incorporation. Certificate of incorporation. So that's the end of that. Like I want us to comments on this area of membership of a company. Membership of a company. Topic number 3. Membership of a company. Membership of a company. Membership of a company. Membership O a company, membership O a company, membership O a company. So in this topic, we learn about who is a member of a company, who is a member of a company. We also learn about who is a member of a company. We'll also look at the concept of membership, member versus the concept of member versus shareholder, the concept of member versus shareholder. We'll also be able to look at how to become a member of a company, how to become a member of a company, how to become a member of a company. We'll also look at cessation of membership. So we have what we call cessation of membership, cessation of membership. Cessation of membership. So apart from having to look at cessation of membership, we are going to look at so you have cessation of membership, how to become a member versus shareholder, who is a member of a company, register of members. We look at the register of members, and beneficial owners, register of members and beneficial owners, register of members and beneficial owners. Then we'll be able to look at another famous case law here. It is known as the majority rule. The majority rule, sometimes we call it force versus habitual. Force versus habitual. Force versus habitual. Then we have what we call a representative action. Representative action. Then, of course, also we go to what we call a derivative action. Derivative action. So these are the key areas you need to look at under this topic we call membership of a company. The topic we call membership of a company. Membership of a company. Yes.
The branch before, so
So we can start by looking at who is a member of a company. So we're having to look at who is a member of a company. So we simply define a member of a company as this is actually simply a person whose name appears, the person whose name appears, the person whose name appears in the register of members, in the register of members of a company. So when you talk about a register of members of a company, this one is just actually an listing of all those ones who can be seen to be members of a company. So once your name actually appears there, then you can be able to say this is indeed you are actually what a member of the company. You are indeed what a member of the company. So once you find a way, having been able to become a member of the company, your name will be listed here. Then once your name appears there, it will become a member of the company. So that basically brings us to ways as why in this case you can end up having to be a member of the company. So you're saying person whose name appears in the register of members of a company will be referred to as having to be what? A member of a company. So how will you find your name having to be there? How will you become a member of the company? How will you become a member of what? Of the company? So ways as to how you can end up having to become a member of the company. So number one way how you can end up having to become a member of the company is through having to be allotted what? Shares. Having to be allotted what? Shares. Through allotment of shares. By allotment of shares. Can have by allotment of shares. You can have by allotment of shares. Number two, it can be through, in this case, taking up qualification. It can be through what we call taking up of qualification shares. It can be through what we call transfer of shares. It can be what we call transfer of shares. It can be through what we call transmission of shares. It can be what we call transmission of shares. It can be what we call transmission of shares. It can be through what we call the doctrine of ESCO. Through the doctrine of ESCO. The doctrine of ESCO. It can be through what we call the doctrine of ESCO. Through the doctrine of ESCO. It can be through subscribing to the memorandum of association on formation of the company. Subscribing to the memorandum of association on the formation of the company. On the formation of the company. Subscribing to the memorandum of association on formation of what? Of the company. On formation of the company. Or the formation of the company. Subscribing to the memorandum of association on formation of the company. So these are just by some of the ways. So as long as these ones are actually ended up having to happen to you, then in that case, it simply means that you become a shareholder. All those ones you looked at, they lead you to happen to become like a shareholder of the company. Then eventually, you'll be considered to be a member of the company by your name having to be included in the register of members. So you can be able to see how it actually ends up having to arise. You must, in this case, for example, find yourself in a way having to become a shareholder. Then eventually, once you become a shareholder, then facilitates that process of including your name in the register of members. So once they do that, then you can be able to consider as having to be what, a member of the company, as having to be a member of the company. The first one, we've seen through allotment of what? Of shares. So a company can end up having to do, for example, an initial public offer. For example, you remember what we learned about a promoter. We say, for example, the promoter is having to form a public company. He can facilitate or enable the selling of the shares of that what? Public company. So eventually, people will apply or subscribe for the shares. Then there'll be an allotment process. Like normally in this case, facilitated or maybe approved by the board of directors. So you'll be able to allot shares. For example, all of us here, a particular company has allotted shares, you can subscribe or apply for the shares. Then eventually they can be allotted to us. What will happen? We'll become what? Shareholders in that company, and eventually become what? Members of the company. Become members of the company. It can be through what we call what? Taking up of qualification shares. What are qualification shares? In any case, for example, you are being appointed to be a director in a company. In any case, for example, if you are actually appointed to be a director in a company, you will likely be called upon to take up some shares in the company to become like a part owner of the company. To become like a part owner of the company. For you to be able to make prudent decisions pertaining to as how the company is actually run, probably in this case, you should actually be part of the owners. So in this case, you make decisions that also do what affect you as one of what the owners. So in that case, you can actually be called upon as a director to take up some shares in the company. Those shares you can be called upon depending upon the articles of the company. We call them what? Qualification shares. And as a result of that, you as a director, you would have become what? Shareholder, and eventually what's a member. So qualification shares are simply shares allotted the directors of the company once they have already done what's been appointed. Financial prudence, in this case, it is required for them to take up shares because they'll be there once will be having to run the affairs of the company. For them to run the company prudently. So of course, now in this case, they should be like part of the owners. As they make decisions in this case, also they will affect them as what? As members of the company or as shareholders of what? Of the company. So it can be through having to what? Take up what you call what? Qualification shares. Taking up what you call what? Qualification shares. Then it can be through what we call transfer of shares. And the transfer of shares, the company have two parties. You can have the transfer and the transferee. So the transfer is not that transfer the shares, not because you have what the transfer. In today, I transfer my shares to Anjiro. Anjiro itself will become a member in that company. I'm having to do what? Transfer the shares. So we say in a public company, there's actually called what? Free transferability of shares. In a private company, you can force transfer, but with a lot of what? Restrictions. See, if I happen to transfer my shares to Dawn, it simply means that in this case, Dawn will become a shareholder and eventually become what? A member of the company. A member of the company. Then we have transmission, which is almost similar but not the same as transfer. Transmission of shares happen in a situation whereby we have death, bankruptcy, we have death, bankruptcy, or insanity of a member of a company, So in case a member of a company has died, in this case, the shares will be transmitted to the beneficiary, who could be the one who has actually been listed under the will. For example, in this case, if this person died but tested, yet a will, so it is supposed to be administered, as supposed to take up the shares. Or it can be through what we call what? Bankruptcy. But in this case, the share of the company are Minnesota. So it's basically the shares are going to go to the person we call probably a receiver. The receiver. Or in this case, it could be through what we call what? Insanity. So it has been declared to be insane. So in this case, we can have maybe a trustee who can hold the shares on behalf of this insane person. So they can be given to that person. So once they give that person the shares, for example, they facilitate the transmission to the beneficiary. The beneficiary becomes the shareholder and eventually becomes what? The member. So the beneficiary will find himself having to become a member of the company. So it can be true in a situation whereby, for example, death, bankruptcy, or insanity of a member has done exactly happening. See, if a person is declared to be bankrupt, so in the sense that a corporate entity or actually an individual, his assets are normally taken up by a person before what a receiver to manage them. And of course, shares are part of the assets. They can be taken up by the receiver to manage them, to pay what those persons who are claiming for the amount from you as a bankrupt person. That is the case. Then of course that the receiver becomes what? The shareholder, and eventually become a member of the company. Through the doctrine of Aristotle, or the principle of Aristotle, the doctrine of Aristotle can arise in a situation whereby, for example, your name appears by mistake in the register of members. And during that time under which your name actually appears by mistake, you still actually continue to enjoy the rights of a member of the company. So, but when I to enjoy membership rights, for example, ukilipa dividends unachangamkia, ukilipa dividends unachangamkia. Wakicall upon for you to, in this case, to go for meetings, unapiga kelele kwa meeting kabisa, una participate. So in that case, how you are able to conduct yourself, it can be presumed you are still what, a member of the company. So you can't deny the fact that during that time under which your name was actually appearing by mistake, according to how you conducted yourself, that you are not what, a member of the company. So in that case, for example, in this case, your name appears in the list of members by mistake. And as a result of that, you still continue to enjoy membership rights of the company. In that kind of a situation, you will still basically be considered to be what? A member of the company. Any liabilities or happenings concerning members of the company during that time, utakuwa ndani ya mix. Utakuwa ndani ya mix. Huwezi ruka. Because in this case, at all you conducted yourself, it's like in this case, you are still what? A member of the company. Until the point maybe they discovered that your name is not supposed to be in the register of members. Maybe you're supposed to be removed, but of course, in this case, exactly what? A step. Then, of course, by subscribing to the memorandum of association on the formation of what? Of the company. So you talk about subscribing to the memorandum, there are those who have actually agreed to be the first-time members of the company. Before the company is actually registered, they are supposed to sign the memorandum and of course indicate how much they are going to take up as shares in the company as members of what? Of the company. So as a result of that, they end up having to be what? Members of the company. Due to the fact that they subscribe to the memorandum, they agree to take up some shares in the company on the formation of the company, and therefore they become what? Members of the company. They become members of the company. The company secretary, not necessarily, that in this case, he becomes a member of the company, not necessarily becomes a member of the company. Not necessarily becomes a shareholder of the company, but for directors, it's like it's a requirement, it's only a requirement. You know, in this case, members of the company, shareholders are not there to run the company, so they have given them the mandate. So it is assumed that in this case, if they become also shareholders, then potentially of seniors. So what you are, we are part of the owners. We need to like drive this thing. Is like they need to own it. They need to own it. They need to like own it. When they own it, then they can run it fairly. They can run it fairly because they are what part owners. So these shares, they are called upon to take up the shares. The standard is actually normally required that in this case they take up the shares within a period of 2 months or 60 days. Within a period of 2 months or what we call what 60 days. Otherwise, you see later on under the topic of directors, they can be disqualified from having to continue to serve as what directors simply because they have not taken up what the qualification shares. They have not taken up the qualification shares. They have not actually taken up the qualification shares. Then we have the concept of member versus shareholder. Along the discussion, you've had me having to mention that you become a shareholder, then eventually become a member. Along the discussion, started this particular topic a while ago, you've had me having to talk about become a shareholder, then eventually become what? A member. So there's that concept of member versus shareholder. Ideally, according to what I've been able to explain, you can just be able to realize a shareholder of a company is a member of the company. A member of the company is actually what? A shareholder of the company. So these two terms can be used interchangeably, simply to mean one and the same thing. They can be used interchangeably, simply to mean one and the same thing. But there arises a situation whereby you can end up having to find out that in this case, a member of the company is not what? A shareholder. Or a shareholder of the company is not a member of the company. So what are these circumstances? The circumstances where a member of a company is not a shareholder, or the vice versa, So the situation will be the circumstances under which you end up having to find out, in this case, person who just only be a member of the company and is not actually what? A shareholder. Or in this case, it's just a shareholder, but is not actually what? A member of the company. Number one situation is in a company that is limited by guarantee. 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 In a company limited by guarantee, this type of a company doesn't have what? Shares. So you cannot in this case say, for example, in this case we have what? Shareholders, but of course you have what? Members who are guaranteed as to how much they can contribute towards the assets. In that case, the company is done what? Exactly liquidated. So in a company limited by guarantee, there are no shares, there we don't have shareholders, we only have what? Members. So that is situation number one. Situation number two, it is under transfer of shares. Under transfer of shares. When the facilitation is having to be done. When the facilitation of the transfer is having to be done. When the facilitation of the transfer is having to be done. Transfer is having to be done. The facilitation of the transfer is having to be done. So in this case, we'll be able to see in our next topic how transfer of shares actually normally happens. That it can take a while. It can actually end up having to do a take a while before eventually the approval is actually done for the shares to be transferred to the other party. So you might end up having to realize, so we have Dawn, and we have Joe here. So Dawn is actually the transfer of the shares. Transfer of the shares. It simply means initially, Dawn is actually what? Still exactly a member of the company. But now in this case, it's having to transfer the shares to me. So remember in this case, when the shares are going to be transferred, I am able to pay what you call what? A consideration. You enter into an agreement, and of course I pay a consideration. I'm able to pay for the price of the share to Dawn. So at the point in this case, you're having to enter into an agreement, sell the shares and already pay the consideration. It simply means that Dawn has already lost what? The shares. The person has become the shareholder exactly what? Mr. Joe. But in this case, in the company, this one, because you'll be able to transfer them, then we deposit in the company and call upon them to do what? Facilitate the documentation to enable now me to become what? A member. But it can take what? A while. So during that moment, Dawn's name will still appear what? In the register of members. It can be a month. But now in this case, he would have already lost what? The shares as per our contractual agreements. So it simply means that in this case, Dawn is a member, but shares bado konazo ashapoteza kwa nani? Kwa Joe. On the other hand, Joe akona shares, he's a shareholder, but jina yake bado haijaapia kwa register of members. So in this case, this person, the transferee, will just be a shareholder. But in this case, he needs to be a member because his name is not actually yet where in the register of members. But once they facilitate, then what happens? More you can then they put my name after a month when the board of directors have done properly, in this case, approve the transfer. So another situation is under this case, for example, you're calling what? Transmission of shares. Transmission of shares. So automatically by operation of law, the parties we talked about, once, for example, death happens, once, for example, death happens by operation of law, it simply means that the beneficiary is one who's having to do what? Take up the shares. So mtu amekufa haizi kuwa in this case still actually have to hold on to the shares. But before in this case, for example, they undertake that process, maybe by the company secretary to undertake that process through maybe having to that will having to be administered by the administrator. To facilitate in this case, the share now to be the name of the beneficiary. This person who has died, his name will still be appearing in the register of members. And in this case, automatically the operation of law, this person, the beneficiary, has already become what? A shareholder of the company. Because automatically, once they administer the will, is a document recognized legally. So once they administer it, it simply means that the person who's actually the shareholder of the company is yours because we are able to look at the ways of shares. The way name shall appear. So now in this case, this person name will take a while. He's already a shareholder, and in this case, not a member. So this one has already done, has lost the share, but his name is still appearing in the register of members. Remember, there's something I've been able to mention. A member of the company is a person whose name appears in the register of members. In the register of members. So you see that basically, if you seem to be a member, when you get the list, you see it there. But in this case, the process hasn't yet, for example, been finalized. So maybe facilitated. It hasn't, for example, this has been finalized or maybe done, but maybe facilitated. So those are just but some of the situations with the circumstances whereby you could end up having to find someone who is actually a member of the company and is not a shareholder. Maybe in this case, he's a shareholder and he's not a member. But ideally, you say primarily that in this case, the term member and shareholder can be interchangeably used to mean one and the same thing. A person is a member of the company, will quite obviously be what? A shareholder of the company. A person who is a shareholder of the company will quite obviously become what? A member of the company. A member of the company. So examiner can be able to ask you this particular exceptions you need to be able to remember them. So we've looked at ways as to how you can become what? A member. So how does cessation of membership happen? How?
When under these circumstances under which you can maybe become a member and a shareholder,
Okay.
and we refer to a situation whereby, let's say we have a celebrity who is well known, let's say, for example, now in Kenya, someone like Omanyala, the under. And then we have this like Toyota company, he's doing well. Now they're using him maybe as their member. So he doesn't own share with that company. But they usually put a brand, it's a brand ambassador. Can we refer that situation as is a member, though it doesn't it's not a shareholder?
Ideally, simply means that it's just like an official whereby you've been employed. If you've been employed, it doesn't mean that in this case you are actually an employer of Safaricom. You are in this case, for example, what? A member of Safaricom. You're just what? An employee. Until the point you as Omonyala, you buy shares in Safaricom. You're just what? An employee. So it's a concept of what? Employment. That brand ambassadorship can be terminated anytime. So it's not what? A member of the company. It's not a member of the company, it's just an employee of the company. Like any other employee who could come under contract to work, then it goes. Yapeli does what Yapeli goes. So the only ways how you can become a member is of the gentlemen. This, and most of them you can be able to see. They are leading you to having to do what? Get shares in the company. The only one that you don't see is exactly what they don't know. Let's talk about ile inaapia by mistake. Hilo tumesema tu peke yake ni inaonyesha tu by way upate share. But hizi zingine zote ukiangalia tunapata zinafundisha kupata ni share zile the company become a shareholder and eventually towards become a member. So what Omanyala must be able to do is he is supposed to become what? A shareholder. For us to say he's a member of that what company. But if that has not actually happened, he's just an ambassador of that company. As an employee, maybe they pay the monthly or maybe this guy is a package for a period of time. I don't know if that's a bill, so like that. That is what just having to be utilized as what as an ambassador. So if you enter into a contract to do that, this going to facilitate that. So cessation of membership, we can look at cessation of membership, cessation of membership, cessation of membership, cessation of membership. So amongst the ways we've been able to mention, you become a member, they also appear under cessation. Which ones do you think they are? Which ones do you think they are? Among the ways you say you can become a member, they also appear as ways as well you can cease membership. Cessation of membership of a company. Cessation of membership of a company. Among the ways you mentioned how you can become a member, there are two of them that still actually appear as ways as how you can cease to be a member. Which ones do you think they are? And death. So death is exactly under what? Under transmission. So you can have death, bankruptcy, insanity. Then number 4, there's another one.
So you can jump
Voluntarily, but the one I was looking for is transfer. Transfer shares, there's two ways. Dawn is ceasing, job is becoming. So transfer and transmission, all these ones come under transmission. So they come under transmission, but you can break them down in an exam situation to score more marks. But the idea what transmission. So transmission and transfer appears in both. So transmission and transfer appear in both, because under transmission, that member of the company who has died loses membership. The one who has become bankrupt loses the membership. The one who has become insane loses the membership. Of course, under transfer, the transferor loses what? Membership. The transferee gains membership. The transferee gains membership. So of course, there's the others. For example, you say voluntarily. Voluntarily relinquishing your shares. So voluntarily relinquishing your shares. If you voluntarily relinquish your shares, then in this case you lose what? Membership. So we can do say buying surrender of shares. Yes, what about? For example, giving out maybe instructions to not actually become a member of a company. Maybe we can be able to say where there is actually a court order that one should exactly be a director of the company. So, or in this case, you can be able to say failure to take up maybe qualification shares by a director to end up having to make that director to lose what? Membership of the company. Membership of the company. Or maybe in this case, the court gives out an order, a particular person to the serve as what? Maybe a director of the company. So maybe this case, it depends on the court order, which basically will end up having to elaborate what could be the result. Another one is, for example, mortgaging of shares. Mortgaging of shares. Mortgaging of shares ni sasa umetumia shares zako kama security for loan. Mortgaging of shares. Remember shares unaweza pia peleka kwa sako, peleke share certificate waambie nataka loan na wapatia, because ukidefault wanaenda wachukue hizo shares. So mortgaging of shares, because you end up having to default on payments of a loan. So the shares will be taken up, and of course you lose what? Membership of the company. We can talk about, in this case, liquidation of the company. You cannot actually be a member of a company that is not actually in existence. So the company is declared to be liquidated. Lose membership once the liquidation process has basically been finalized. So liquidation of the company. Liquidation of the company or winding up of the company. Liquidation of the company or winding up of the company. Liquidation of the company or winding up of the company. Then we can talk about lien on shares. The number of that numbers lien on shares. Exercise of lien on shares. Exercise of lien on shares. Exercise of lien on shares. Lien on shares is, for example, in this case, if the company is allowed under the articles to, for example, hold on to your shares, if in this case you are actually indebted to the company. Inaweza kuwa wewe ni shareholder kwa hiyo kampuni na pia wewe ni customer. So kampuni wewe inakusupply goods on credits. Then inafika mahali umeshinda kulipa. So what happens? Kampuni inachukua shares zako wanazishika. Huwezi fanya kitu yote, you can't transfer, you can't deal with the shares in whatever way until utalipa hiyo deni yako kwa hiyo kampuni. It's just the same case. For example, it can happen under sale of goods. If it happens, you've been able to buy goods as a customer from this case, our personal suppliers. So you won't be able to release the goods until you pay the price. Could have entered into an agreement next the supply. Is a contract, but you pay what? Maybe a card. So you end up having to wait for you to pay for the 2 cards for you to be able to release. That aspect of you having to hold on to them until you pay is what we call what's lien. If it's goods, it's the lien on goods. If it's shares, it's lien on shares. Lien on shares. So let's say, for example, you're being supplied items on credits by the company in which it could be best, maybe in this case you are showed as Safaricom. So you run in this case a Safaricom shop. So they supply you, for example, different kind of items. Could be phones, could be airtime, scratch cards on credits. And this is what has happened. You defaulted on payment. So Safaricom is actually allowed under its articles for you to be able to hold on to your shares. So they hold on to your shares. If you don't actually end up having to pay, they'll take up the shares. If the articles allow. And of course, you lose your shares and eventually lose what? Your membership in that company. Lose your membership in that company. Another way, as far in this case, it can happen is through what we call redemption. Redemption of preference shares. Redemption of preference. Redemption of preference shares. Redemption of preference shares. Redeem preference shares. Redemption of preference shares. So these are kind of preference shares that in this case, whenever they redeem, you can buy them back. Redeem simply means to buy them back. So maybe in this case, you've already utilized the capital they provided as preference shareholders. You no longer need it. What you do, you buy them. So you pay capital, you pay pesa. That's what now you share your pesa. Alafu wanarelinquish hizo shares. Those ones who in this case will relinquish the shares, they will no longer be shareholders of the company. And eventually they lose what? Membership of the company. So under redemption of preference shares, the holders of preference shares, they will lose their shareholding in the company and eventually lose the membership of the company. Lose the membership of the company. So under redemption of what? Preference shares. And then another one could be forfeiture of shares for non-payment of calls. Number 10, forfeiture or cancellation of shares, forfeiture of shares for non-payment of calls. Forfeiture or cancellation of shares for non-payment of calls. Forfeiture or cancellation of shares for non-payment of calls. Shares for non-payment of calls. So when you talk about some call, sometimes in this case, when the company floats and actually allots the shares, they can, for example, agree that in this case on allotments, you pay in this case 60% of the face value. Then they can have the first call where you end up having to pay 20%. In the second call, they can call upon you to pay the other 20%, in total what 100%. So this call is just a notice to you as a shareholder that in this case you pay any outstanding amount of what on your shares. So they can make that call Then you get to America will be the rest of the concept paper. They make the second call concept paper. If the articles of association, the rules governing the internal affairs, you can be able to remember very well. We say part of what is normally contained in the articles are simply rules pertaining as to, in this case, calls and for page of shares will be done. So the articles allow in this case, if you fail to make a payment on your call, the company can simply forfeit it or cancel out your shares. And eventually you do what? You lose your shares in the company and you lose your membership. But the articles of our association of that company should be able to provide for such.
Because even this.
Yes,
Yes,
so long as the articles, the rules governing the internal affairs indicate they can forfeit, you lose even what there 60. So they likely depend upon the provisions or the guidelines of this particular document. This particular document, if it actually provides for they cancel out all your shares, you will lose the 60. But if they actually provide for you, they give you back the 60% amount you pay, it will be okay. So they give you back, and because you do what you lose the membership. But if in this case doesn't provide for such, they can cancel out all your shares, and eventually you lose membership of the company. You lose membership of the company. You lose membership of the company. That's what you mean by forfeiture of shares for non-payment of calls. Non-payment of calls. And payment of calls. So I think we can end there. So let's end there for now. So I think in our next class, we'll be able to look at other issues. I think we look at past paper operations. We look at some past paper operations in our next class before we continue. So before we continue,
Just one thing.
okay.
That's the doctrine of the rest of them. Really have been you find yourselves appearing, your name appearing in a company by mistake.
So
That really happened.
it is rare, but it can happen. It's rare, but it can happen. It is rare, but it can actually do what it can happen. It can happen. For example, in this case, it can appear by mistake, but say your liquid evidence kulipa dividends ukafanya so ile waliita mkutano ya kampuni ulienda tu participate and you even voted. You even voted. And you know your name is actually appearing by mistake. Then when later on a question is raised pertaining, for example, what were past resolutions unataka kuruka you are not part of it. Huwezi kuruka kwa sababu the way you conducted, there could be an issue before the court. Yes, there can be an issue before the court. Then wanauliza nani walipitisha hii kitu, lazima hapana, jambo linaapia by mistake, means by kuwa nini. Sasa wanakuuliza the way you conducted yourself. So go to the doctrine of Aristotle, the principle of Aristotle, you cannot deny the fact that in this case, you are not party to the members of the company. During that time, the name was actually appearing by mistake. So these are the facts we kusema kwa kwa tunajua the dynamic that we appear by company by mistake.
That's
Why
a
they
very
go for it? So that's why in this case we are saying if that is the situation, then it should still be taken. You are like a member of the company. You're like a member of the company. You're like a member of the company. Yes. Any other question? So this one, how to become a member, very common in the exam, and also how to cease to be a member. How to cease to be a member, very common also in the exam. So you can put there like this, for example, 10 marks. Then they tell you explain like 5 of them. Or they can put there, maybe they can ask how to become a member, they put there 8 marks, then you set 4 to actually explain. So you need to take notes. So it's very common how to become a member and cessation of membership. So they like having to test those particular ones. So because we have others, we'll be able to look at next time as we look at what the past papers. We look at the past papers before we proceed with membership. So we are like to finish up with this topic maybe in the next class, but we'll be able to see what will happen. It is not that long like formation. Then technically in this case, formation of companies is a very key topic in the exam. Formation of companies, the one we just covered talking about, is a very key topic in the exam. It is the most tested topic in company law, the most tested topic in company law. So an analysis of the past paper questions over the years shows that the majority of the questions have actually come from this particular topic. the majority of the questions have come from this particular topic of formation of companies. So they like it, they really like it. They like having to test it. So as most of the questions as per the analysis of the past paper questions. So it is one of the major areas. In this case, you're like 100%, they will test a question from formation companies. A question from formation companies will be there. So I think we'll be able to look at some of them in our next class. Of course, we'll be able to see how you can be able to handle them, how you can be able to handle them. So let me bring this down.
That's right. Yes, okay, this.
Together just to be you know,
Since our